Like, so, I'm gonna give Sam your number. All right, and we'll figure it out. All right, cool beans. All right, bye-bye. Shit, starting.
Hold on, hold on, hold on, hold on.
Hey James, how's it going? I think you're on mute.
Can you hear me?
Yep, I can. How you doing?
Good, man. I got the headset working and I'm on, baby. How are you?
Oh, you still look like a whole YouTuber. For real. Like, honestly, James, like I'm waiting for your Twitch. Let's go. We got it. We can get this going on. Come on.
One of my interns wanted me to do he wanted me to hit the gritty for something, and I tried it. I'm like, no, man. We can't get that out in the public. Rhonda!
Oh, my guy.
I'm good. How are you?
You all ready for the holidays?
No.
I don't know what happened this year, man. It just came too fast. I'm just gonna hide.
Me too.
Close for business.
Yeah, I'm planning. I'm gonna try to get sick so I can use that as an excuse.
Yeah. Well, we could go out somewhere and we say, yeah, we came in contact with COVID. We gotta stay away from everyone.
Yeah, I can't.
Sounds like a thing. All right, good to
Merry Christmas. All right, let me get some stuff open so I'm
Mhm.
ready. Take some notes. Booyah, booyah. Oy, oy, oy.
Oh yeah, I made that addition to the agenda as well. So everyone, you and everyone else should have that as well.
Perfect. Yeah, let me open up the agenda. I gotta do that. Then I'll close my email because I don't want to get distracted. Okay, so we have 5 things on our agenda, and I can take my notes down below. I have the AI Bill of Rights here, print it out. Okay. So this should be good. We'll see. You go anywhere for the holidays, Sam?
Nope. My location is my bed. That's it.
Didn't you do some cooking and stuff last year?
Oh yeah, no, I'm definitely the family chef now for Thanksgiving,
Okay.
Christmas, Easter, all the holidays. So I'm definitely going to be cooking, but then after that, I'm going to sleep.
Nice.
Yeah, literally, this is my I call it my hibernation season. Yeah. And then I'll reappear on New Year's, and then I'm disappearing on New Year's Day, and then I'm going back to work.
Yeah. I'm putting on all my hibernation weight, but I don't think I get to hibernate.
Oh, nah. What was it? I was talking to my nephew and my little cousins the other day, and they were all excited for Christmas, and I just wasn't having it. And I was just asking myself, when did Christmas start becoming more like a deadline and not a holiday?
Yeah, I know, right? I feel bad, right? Yeah, it just feels like something to check off now, like,
Yeah.
so when did it become stressful instead of like the center of your universe? Like when I was a kid, everything was counting down till Christmas.
Right.
You know?
Right. But I mean, you know what? It is what you make it. I mean, it's the adults that make the holidays what I loved about it. So now it's like, because I am a whole adult now with health insurance,
Yeah.
that's not fun. But I mean, I gotta make it as fun as possible for myself now. So yeah, yeah, I get what y'all were doing now, and I give adults a lot of respect because this is a lot of work you gotta do for your kids.
Yeah, but it was more fun. Like, so it goes in, right? Like, it's like obviously the center of summer vacation and Christmas are the 2 things that a kid's life revolves around, at least for me,
Yeah.
And then it gets for a little while, like it's not as exciting for Christmas. But then when my son was little and believed in Santa and all that,
Oh,
it's
yeah.
not exciting for a while. But now he's like a teenager, so it's not
How-
quite as much fun.
Yeah. Oh yeah. Oh yeah. Oh yeah. I remember that. Oh, now it's like, look, I know Santa's not real. Just give me cash and I'm set.
Yeah, yeah.
Give me cash or a PS5. I'm good. I'm good.
Oh yeah, yeah. My son is gonna get his driver's license.
Oh,
Uh,
really?
yeah.
Is he getting a car?
I was just thinking I should get him a Matchbox car. Here's your brand new car for Christmas. But no. Well, he is like my wife's brother has an old car and he just bought a new car, so he's gonna give us his old car for my son. But even that, like, yeah,
Hey,
we
when I was 16, my dad gave me wiper fluid. He said,
yeah,
car, you got to buy it yourself. I'll get you the wiper fluid though.
yeah. I didn't have a car till I got out of college and got a job and bought one.
Mhm.
But well, we did like once I went away to college, my dad got a new car and gave the old one to my brother and sister. And they're younger, and I had to fight with them to get the car when I came back from college, But I didn't have one. It was nice, man. Toyota Corolla with 200,000 miles and
Mm.
lots of dents. So people saw me coming and they knew what they were in for.
What was it? What did I have? I had a 95 Jeep Cherokee. And then she died when I was in college.
Ah,
Yeah.
all right, how many people do we have?
About 15, almost 20 people now. They're all slowly coming in now.
Okay, yeah, it's 10:59. So we'll probably do the same as usual and
Mhm.
wait until about 11:04, 11:05 to get
Okay.
started.
Yeah. Well, we at least have Sharish on right now, so he's the first presenter.
Yeah, right. So that's the most important thing. Now, do you need Professor Venkata Subramanian? Is that remotely
Ve-
close?
Venkata Subramanian. Yeah, it's pretty close.
It is. Okay. Um, Sam, have you enabled screen sharing?
Yes. So Professor, you should be able to just look at the bottom of the bottom of your screen. You should see a green icon that says share screen. When you're ready, you can just click on that and then click on the presentation that you want to present, and then you should be good to go. There we go.
Let me know when you'd like me to start.
Okay, great. Yeah, we'll probably start in a few minutes. So we'll just welcome people. As people are joining now, we usually end up getting started a little around 11:04, 11:05. I have 11:01 on my computer, so we'll get started in 3 minutes. Perfect. I got this top screen. So where is that? Idaho. Okay. Idaho. Okay, Sam, how are we looking? There's still people.
Still people coming in. We still have a few more presenters. I'm waiting to come in, but I'm sure they'll probably come in as the time goes on, like last time.
Okay,
So
And-
we can just everything's all the recording equipment set up, so we can start whenever everyone's ready.
okay. We'll get started in one minute. Yeah, and I like Assembly Member Wick and Senator Rodriguez probably won't get on until closer to their times. They're in California and Colorado, respectively. So is Carl Zabo on?
I do not see Carl yet.
Okay. Okay, Tim, why don't we get started?
Okay. Whenever you're ready, Mr. Chair.
Okay, thank you very much, Mr. Clerk. Good morning. We're calling the 12/14 meeting of the Data Privacy Working Group to order. We'll start by asking Representative Gilchrist if she has any remarks.
Great. Thank you, Senator. Good morning, everyone. Just looking forward to learning more today. Thank you.
Thank you. And at some point, I'm looking forward to learning more about a great photo I saw of you on Facebook with with President Biden. So that'll be not today, but another time.
Happy to share the details.
Thank you. And Representative John Michael Parker will be joining us at some point during the meeting. He won't be able to get on right away. So with that, we'll get started. We do have 5 presenters today. Today is our last. Well, we have one more meeting of this before the session, right? I think January 3rd, but today we're very lucky to have presenting to start Professor, and I apologize again if I butcher your last name, but Suresh Venkatasubrahmanian from Brown University, and he's going to present to us about the White House's blueprint for an AI Bill of Rights. He had worked on that, and he is a Brown University professor. So, Professor?
Thank you very much. So I'd like to thank Senator Maroney and the Data Privacy Working Group for giving me the opportunity to speak here today. I'm a computer scientist by training. I'm a former White House tech policy advisor in the Biden-Harris administration, and included in my portfolio was developing the blueprint for an AI Bill of Rights that I'll talk about today. I've spent the last decade or so studying and researching the impact of automated systems and AI on people's rights, opportunities, and abilities to access service. I helped create one of the major venues for academic research in the space, and I've also spent time working with civil society groups, as well as advising state and local governments on sound approaches to governing the use of technology that impacts people's lives, including stints with the state of Utah, New York City, and the First Judicial District of Pennsylvania. And I'm here today to talk about the Blueprint for an AI Bill of Rights, what it is, why the White House drafted it, and what it can offer as you think about algorithmic governance broadly. So a brief history of how the document came to be. It started really with an op-ed in October 2021 in Wired magazine, arguing that Americans need a Bill of Rights for an AI-powered world, and with a vision of developing principles to guard against powerful technologies that have many benefits, but also potentially many harms with input from the public. This process was a long process. It took over almost a year from initial declaration of intent to the actual report. After the op-ed, the White House organized a number of convenings on specific topic areas, including criminal justice, consumer protection, civil society, civil government sort of actions, health, technology, and so on. These are public convenings. The videos are available, and I can submit that after this discussion. We had a number of listening sessions with the public. So these were sessions where anyone from the public could join a Zoom call and share their thoughts on AI governance, especially in the context of biometrics. We had a specific request for information on biometrics that was analyzed later on. All of these inputs led to the drafting of the initial version of the document. And that led to a whole series of engagements inside the U.S. government with virtually every agency that has interest in AI. And that's an interesting sort of point that I'll come to later on as well, how AI is cross-cutting across so many different parts of the U.S. government. And then finally, the document was released this October, October 4th. Many of you may have seen the document already, and if not, I can give you a brief highlight. The document consists of the following things. It consists of 5 principles to guide the design, use, and deployment of automated systems. And in addition to these 5 principles, which I'll talk about in a second, it has a technical companion. The goal of the technical companion, and the reason why this document is 73 pages long and not 5, is because we viewed it as very important that we explain the importance of each principle, set out expectations for implementation at the level where literally a software developer could look at the expectations and understand how they might write code that complies with it. And also give many examples of how these principles have been moved into practice already. So this is not something that's coming out of the blue. It reflects ongoing discussions and movement across the board in different sectors and different levels of government of people trying to instantiate these principles. Another point worth making that comes up a lot in these discussions is what is the scope of such a document, or what's the scope of any kind of governance? And in this document, specifically, the scope was articulated as any automated system that can meaningfully impact the American public's civil rights, civil liberties, privacy, opportunities, whether it's in education, housing, credit, and so on, or access to critical resources and services. In particular, it's not just about AI. While AI is definitely an example of such a system, in the document's view, the scoping was constrained by the impact on people rather than on the nature of the technology itself. And this is important because technology changes, but impact is something we understand. So to that end, what were the rights themselves? And there are 5 of them, and they're fairly intuitive, and I think that's a good thing because it reflects what are very, I think, natural concerns about the use of technology. First of all, things should work, and they should work well. We don't want unsafe or ineffective systems out there in the wild. And it's unfortunate we have to say this, but it's often the case that things are put out in the world without being tested for being safe or effective. Needless to say, these systems should not discriminate, right? Algorithms should not create discriminatory outcomes, that if a human were to be doing would look discriminatory in a formal legal sense. There shouldn't be reckless use of data without control. Now, I know that we already have guidelines, including in Connecticut, around data privacy. The guidelines here go beyond that because it talks about how data gets used and reused in an entire pipeline of inferences. And often it's not just about the initial point of collection, it's about how inferences about individuals are then fed into other systems, which create more inferences and more decisions in a way that can be problematic and that need to be regulated and supervised carefully. In all of this, it's very important that before we can think of any kind of governance of these systems, that we know they're being used. So this idea of transparency, right? You notice an explanation. You should know when automation is being used and how it contributes to outcomes that impact you, right? So this is the idea of explanatory systems that people have been talking about a lot. And finally, and this is something that's not often talked about, but is definitely a concern that we wish to address, was that there should be a form of human consideration and fallback. And the reason is that no matter how well systems are designed, they do fail. And systems that affect people should be part of a broad structure that actually does work, which includes having human backups. Yeah. For example, if you go to a voting booth and you have a system that doesn't work, there are ways to assert your right to vote that don't require technology and things like that. So these are the 5 principles. And with each of the principles comes sort of detailed explanations, as I mentioned earlier, of why this principle is important, what we can do to make sure this principle is preserved when an automated system is deployed, and what people have tried to do about this already. And I think it's, before I go deep into any one of these, it's helpful to understand that these principles are not meant to be viewed as independent. They work together, right? So having notice and explanation means that there is ways to have oversight over such a system. Making sure the systems are safe and effective actually often reduces a lot of the risk of discrimination, because systems work well, that takes care of a lot of the concerns around what kind of harms they might be inducing. And so it's best to think of these, in our pandemic world, as a Swiss cheese model with layers of protection rather than them being individual things. They work together well. So what I'd like to do is maybe go into a deeper dive into one of these principles, just to show you the anatomy of how the document is structured and how the principles are structured. I won't go into too much detail. Obviously, that would take too long, but it's just to give you a sense of how each of the principles is structured and why it might be helpful as you sort of think about algorithmic governance in general. And so the deep dive I'll go into is the one on algorithmic discrimination. And I will sort of put up this very intimidating looking slide because it has lots of words in it. And the trick is to not pay attention to all the words, but just a few of them for now, right? So the first words that are important to understand here, and this is true for each of the principles, is an articulation of what the concern is. In this case, what is algorithmic discrimination? Well, it's when automated systems contribute to unjustified different treatment or impacts, disfavoring people based on a number of different criteria that are of concern, right? And not all of these are currently illegal, just because of the way a civil rights law works, but they are definitely of concern. And so that's where the language is. And so with all the principles, and no differently with this one, it's important to articulate why it's important to have such a principle, because sometimes the harms that show up from not having it appear in different forms. So in particular, some of the harms that have been articulated, and these are all citations to actual case studies in the literature, in the press, by researchers. For example, bias in loan pricing for historically Black colleges and universities applicants, hiring tools that have been biased either towards women, actually in this case was against, that's a mistake in my slide, I'm gonna apologize for that. Predictive tools for college dropout, so a tool that says, is this person likely to drop out of college early, that tend to have racial bias in them. Risk assessment tools in criminal justice. For example, should someone be released on their own recognizance? Should they be asked to pay a certain amount in bail? Should they be given electronic monitoring? Are often racially biased. Sentiment analyzers. So this comes up a lot in online content. Maybe a system is trying to determine whether comments are unpleasant or there's content that's problematic and needs to be taken down. We're discussing content moderation right now in the world. And these tools that are used to do automatic content moderation are often biased. And another case study is of individual disabilities are often flagged during when you have remote proctoring exams. Because they have disabilities, they might present differently to a system that might think that they're cheating or doing something and flags them in a way that can be viewed as discriminatory. So once we list out all the ways in which non-adherence to this principle could cause problems, we like to sort of articulate what we should do about it, right? How should we protect the public from discrimination, either proactively in an ongoing manner and provide proof. So there's a lot of detail in this. Again, the document is quite long, but among the things that are included and in specific detail for any particular principle are things like, in this case, proactive assessments of equity, making sure that data is used, only representative data is used and it's robust, it doesn't have problems in it. Guarding against proxies for discriminatory features. You use zip code and what is really representing is a proxy for race, for example. Making sure that there's accessibility, that people with disabilities are not disadvantaged. Doing disparity assessments and ongoing monitoring and mitigation. These are all specific line items which can be instantiated in specific technical ways and sometimes need more work, but are things that are important to make sure that overall a system is not doing algorithmic discrimination. And in all of these, and this is a theme that runs through the entire document, the importance of independent evaluation and reporting. And so again, if we go back to that wall of text that I showed you earlier, but highlight a different set, that the reason why there's a wall of text, because all of these points about proactive continuous monitoring, disparity assessments, proactive assessments are all part of the language of what the principle says. Excuse me. And finally, each principle contains a description of where these principles have been actually moved into practice. So there are examples in mortgage lending, in hiring with disabilities, and disparity assessment in healthcare, standards from NIST, and standards organization for accessibility, where you can see already attempts to do the work of making sure that we have guardrails around systems that are being deployed. And the important thing to recognize is that there are many different levers of change. We can think about legislation as a very powerful tool for effective change, but it's not the only way we can affect change in this space. So that's something to think in mind, that there are many different levers of change we can work with together to make sure these principles move into practice. I had mentioned some themes in the document, and they underpin both the document and the principles, and it's worth highlighting them here. For example, as I said earlier, the importance of reporting. In each of the principles, there are expectations of what a designer of an automated system should be doing, but there's also the requirement to report on this, to make sure that someone independently can evaluate whether the system is doing what it claims to do. And that's why independent evaluation audits are very important. There's a lot of discussion right now about how to build auditing mechanisms for these technologies, whether they should be done by the entity building the software, whether it should be done independently. I think we come down fairly strongly on the idea that you need independent evaluation. An important point in this document that often differs from how others have tried to look at these issues is a focus on harms and not on the technology. Now, there are many reasons for this. One important reason is that technology changes, and technology can be rebranded if people are viewing a particular piece of technology as a problem. As an academic researcher in computer science, I know of a time when actually calling something AI was a kiss of death for it. It's hard to imagine that now, but there were times when people were running very far away from branding what they were doing as AI because that was viewed as a dead area. Now, of course, we're in the opposite space where you're literally an Excel spreadsheet with a macro in it is called AI because it's a way to sell it. And so recognizing that the branding of technology with certain names often is due to strategy, economics, and sort of business reasons, it's important to focus on the harms associated with the technology and not the technology itself, because that can change over time. And harms, I think, is something that governance is an appropriate place to think about. Another thing the document does is recognize that sometimes harms don't accrue to individuals only, they accrue to communities. And that communities should be part of discussions in terms of public stakeholder input in thinking about what happens when a piece of technology gets deployed. And to that end, also, in thinking about technology, the document sort of carefully skirts trying to define AI. If you're following some of the discussion right now in the European Union around the AI Act, there's a lot of discussion happening right now about how to define AI. And there's a lot of controversy about this, precisely because stakeholders with interests in this space are trying to make sure that the definition suits their purpose. And again, as an academic, I can tell you that the definition of AI, while academically represents something, does not look anything like the definitions that people are putting out there in the world. And so it's important to, again, focus on the harms of automation and making sure that the benefits can be realized without getting too fixated on what is currently the main topic of concern, which is AI. I wanted to spend a few minutes. I know you've had previous meetings where you've had great detailed discussions about existing or proposed legislation around algorithm accountability. So I won't spend too much time on that, but I'm happy to sort of get into this in the discussion. I mean, there are some examples, and this is not an exhaustive list, of course, but some examples that stand out by virtue of being, reasonably mature and also reflecting well on how they fit with the document, which I'll talk about. One is, of course, the law in Washington on algorithm accountability, Senate Bill 5116. There's the SDA in Washington, D.C., the Stop Discrimination by Algorithm Act that's under review. And there's, of course, the local law 114 in New York that was about to come into effect on January 1st, but has now been pushed back 3 months because they realized that they need to have more public input on exactly how the bias mitigation process in this tool is going to be used. And so a very brief, short, assessment of how these existing pieces of legislation align with the principles outlined in the blueprint for an AI Bill of Rights. At a high level, all the bills emphasize notice, and this is an important thing. They all say that you have to disclose the use of technology in a decision-making setting. And again, the scoping changes, but that importance of notice is there. All the bills emphasize testing for bias, and that's very important. That's a good thing. Most of the bills don't actually talk about the concerns around data reuse and misuse. I mean, privacy is one part of it, but it's not the whole story. The way in which data gets transmitted through third parties, through data brokers, is not easy to address or well addressed in any of these bills thus far, and that might change, of course. There's very little discussion of the idea of human alternatives consideration and fallback, the idea that you need backups when systems fail. And we, in our view, this is an important part of thinking about deployment of automated systems because, for example, when an automated system was used to do digital identification of people to claim benefits during the pandemic, the system only had a digital component. It failed to work on many people. And then they were stuck waiting for hours and even days trying to get hold of an operator to try and get a backup option to apply for the benefits they were entitled to. This is because the company did not have appropriate fallback in place. It's what's surprising to me, I think, is that none of these bills talk about safety and effectiveness testing, which is concerning, especially since a lot of these technologies get put out without the appropriate amount of testing that they even work in the first place. All the bills do emphasize reporting and impact assessment, so that's okay. But I think there could be a lot more that's done in that space. I want to conclude with a sort of a few remarks. I'm a computer scientist, and part of my job as a computer scientist is to imagine technological futures, both in the teaching in the classroom and in my research. I enjoy thinking about technology. That's why I'm in this space. And there's a future I can imagine where automated technology is an assistant. It enables human freedom, it enables liberty, it enables flourishing, where the technology we build is inclusive and helps us all achieve our dreams and maximize our potential. But there is another future, unfortunately, in which we are at the mercy of technology, in which the world is shaped by algorithms and we are forced to conform, in which those of us who have access to resources and power control the world, and the rest of us are left behind. I know which future I want to imagine and work towards, and I believe it's our job to lay down the rules of the road, the guardrails, the protections, the seatbelts, so that we can achieve that future. And that's why I'm optimistic, but also feel like we should be careful about how we govern technology. I want to thank you for giving me this opportunity to speak, and I'm happy to take questions now.
Thank you very much. I know I have several questions, but I like to leave it open to others to ask their questions first in case someone asks the question I was thinking of, so I don't need to ask it. But while I'm waiting for other people to put up their hands, so if you do want to speak, just use the raise hand function. If you can't find your raise hand function, feel free to just unmute yourself and chime in. You just in general, you started by mentioning you have worked with other governments, I think some local, some state, in their work. How would we engage you to assist with our work? Is there a formal process, or is this it? Just emailing and asking you?
The easiest thing is just to ask, and then we can figure out how to do this. So yeah, I mean, when I was working with the state of Utah, I was just the auditor's office invited me in because of my work in the space, and then I just sat in the commission and we worked together. So just ask. I'm happy to help.
Okay, great. Thank you. All right, thank you, Professor Sudhir. I see your hand raised, and I'll allow you. I'm sure you're going to have some of the same questions I do, since you already told me 2 books. I've read the 2 books you recommended for me to read so far. So.
Thanks, Senator Maroney. Hi, Suresh. I think we have met before when you visited Yale. I was just trying to think a little bit more about the connections between what you have proposed in these guidelines for the US relative to what the AI Act is doing. For instance, one of the things that struck me was there were these levels that were proposed and certain things where AI was completely banned. And I see connections to it, but I was just wondering how to think about the linkages across these two.
Yeah, so and just for those of you who may not have been tracking this, I think what Sudhir is referring to is the fact that there are, in the EU AI Act, there's an articulation of what are considered, banned technologies, high-risk technologies, and I think the rest, which are not considered high risk. And I think the articulation there is to say that we need different treatment. There are things that should be banned and not used at all. And there's some debate over caveats for law enforcement in that space. There are things that are high risk and have a higher scrutiny, both in terms of how the deployment is done and what kind of testing is done. And there are things where there isn't considered a risk. I think that assessment and the sense that not all technology should be treated the same is correct. I think that a judgment about what are high risk and low risk is reasonable. The only reason I hesitate a little bit is because these often can change over time as new forms emerge. One of the early debates within the EU was around how do we get things on or off the list of high risk or banned technologies and so on. For example, a lot of the concerns right now about social credit scoring, which is one of those banned technologies, is interesting because there's a certain political element to it because of this is what China is doing. And there's a need to sort of put a stake in the ground saying this is something we want to do. However, a lot of credit scoring is automated, does use AI in some form to build predictive tools. And so drawing that line between, well, this is banned, but we're using it anyway in some other context makes it tricky again. So I think the sentiment that we should recognize that not all technology is going to be problematic. And that's why in the Bill of Rights, we have the term meaningfully impact. The question is whether you lay this out upfront or you empower some authority to make that assessment in the moment. I lean a little bit towards that because technology changes and evolves, but I understand that can be tricky to have people with the right expertise to do that as well. So I think there's some compromise to be had here.
And related to that, like, the other difference that I was noticing and you emphasized was the independent evaluation of harms as opposed to self-certification, which seems to be like much of the theme in the EU-AI Act. Like, just wanted to get your thoughts on how that discussion went around that.
Yeah, so an underlying theme to a lot of the design of the AI Act is that it's sort of thinking of it through product safety and sort of product compliance. And I think that's where self-certification, right? So the idea being you do, what it is reasonable to say, okay, you do self-certification, and then if there's a problem, we can go back to look at your survey, and then we can sort of ask you pointed questions about what exactly you did. And that's one way to go about it, which is a sort of a product safety, product forward kind of approach. Right? Let's put the products out there and see what happens. And this is not unprecedented. For example, when cars get on the road, manufacturers self-certify that they're in compliant with the guidelines of the National Highway Transportation Safety Administration. And if then a problem comes up, then they go and investigate to see whether the cars were in fact tested properly and what the problems were and whether there should be a recall. So it's not without precedent to have that. I think, again, an assessment has to be made whether certain technologies, if incorrectly used or if not tested for effectiveness and safety, could have such an impact that it's better to do pre-testing. And again, we have models for that within the US. Just staying within transportation, the way the FAA inspects planes is different to the way cars. Cars are put out first in concordance with the guidelines, and then if problems come, they come up. Planes are tested first before they go out, because the risks, of course, are viewed as very different. And so I think there are different models for this. And I think it's reasonable to sort of debate for a given set of governance structure. And I didn't mention this, but the New York City bill, for example, is only about hiring. So if you have something that's sectoral, you might say, okay, well, in this sector, this is the way we think about the harms and the risk, and this is how we should think about whether it's pre-certified or post or self-certified. I think there are different ways to think about this.
Yeah, and so combining the two, right? So the thought was that combining the two, for high risk, maybe we do more independent evaluation, and for lower risk, maybe more certification. And so is there an interaction?
I think so, absolutely. I think that's, to be honest, I would like to say this is what we should do. I don't think we have enough good examples yet. And so I think it's worthy to sort of think about what makes sense in a local context and just try it and then do it that way. I think these are not wrong. I think, but there should be some flexibility to adjust as we see how things play out. If we find, okay, maybe we needed more pre-certification in this thing that we thought was low risk, but isn't anymore, for example.
Thank you.
Thank you. Are there any other questions? Just following on that, I guess I have a few questions. One, I was just interested. It was cited in the blueprint, but the Idaho bill in regards to the pretrial risk assessment. I don't know if you knew anything about that, but I think one of the things when we look at where the AI has, I guess, the highest risk of harm, right? If we're looking at whether, I think you define it in the AI Bill of Rights, the sensitive domains, but it seems like a lot of those areas are government uses. And when we did our data privacy bill, we exempted the government from that data because it was a consumer data privacy bill. But I don't know if you have any thoughts on that, the Idaho bill, or if there are other, I know you had mentioned you looked at Utah, but other examples we can look at. And then another thing let me go one part at a time, and then I have the next question. I'm sorry.
So I would say that in general, there were long debates over scope, and especially the scope to what extent government is, part of the discussion. My personal view, and the view that is reflected document, is that government is within scope, because a lot of the technologies that impact people are deployed by governments, right? So especially in criminal justice, especially in, in benefits and giving benefits to people. These are things where government has an important role to play and would like to use technology as far as possible. So if your question was, how I think about this relationship between scoping with government versus not, I personally believe the government should be within scope. I think, I think that, again, the levers at our disposal are different. For example, a lot of the software that government uses is procured from the outside. And so procurement has been a sort of an interesting vehicle, a common vehicle of choice to sort of think about, okay, if we're going to procure software from the outside, it should have these criteria as a way of even shaping the marketplace around these tools. Because if companies are realizing that tools they sell to government have to look a certain way, they're not going to just completely build different tools for private entities as well. And so this creates change in that sense as well.
Yeah, and that's where I've been thinking about it, is starting with our, when we're going out to procure software and the RFPs requiring some form of impact assessment, disparity assessment. I'm not sure, what would be the correct terminology, but in the procurement of, I guess, the services that would be of potential harm, right? So if you're looking in pretrial risk assessment, but also provision of services. And I think Professor Sudhir had recommended I read the book Automating Inequality, and you see that in housing, like the LA homelessness and the Indiana example for their food stamps, and Allegheny County and whether they were going to follow up on reports of potential child abuse through their, I think it was CCYF in Pennsylvania, CCF in Connecticut. But I appreciate your time. I do have other questions, but I think I can probably just, if you don't mind, I'll reach out to you individually as we start to think about what we're going to do with the legislation. And I'll just see, does anyone else have any questions? Okay, great. Thank you so much for your time and your presentation.
Thank you very much. Appreciate it.
Sam, is Carl Szabo on?
Carl's not on yet, but John Brady is though.
Okay. John, are you ready to present on the potential data co-location issues?
Of course. Thank you. Thank you, Senator Maroney and Representative Gilchrist and the rest of the task force for the opportunity to join you today. Pardon me. In the interest of time, I'm going to keep my comments brief. I don't have any slides, but just wanted to raise your awareness of a potential issue. So once again, my name is John Brady. I'm Senior Vice President and Chief Financial Officer at the Connecticut Hospital Association. I'm also the Privacy and Security Officer for CHA, which gives me a little bit of a perspective on data management, including privacy and security regs and requirements applicable to data storage. However, I brought the A team with me. My colleagues Karen Buckley and Jennifer Cox are also here to assist with any questions or discussion that comes from my remarks. So as Senator Maroney noted, I'd like to discuss co-location today to bring attention to it to ensure that the implementation of SB 6 doesn't result in any unintended consequences, including potentially the reduction or elimination of local options for Connecticut companies, including hospitals and other providers. So briefly about CHA, we're the trade association for Connecticut's hospitals and more than 60 other institutions and healthcare providers in Connecticut. We also have some affiliated entities, and through one of them, ChimeNet, we operate a small Connecticut-based data center that provides co-location services to a number of businesses in healthcare and other industries. Many of you, I'm sure, are familiar with large national and international companies that offer cloud services, which are hosted on shared servers in private remote data centers throughout the country and all across the world. In those circumstances, the cloud host company has a technical role in how the actual data are accessed and maintained on their systems. Co-location, however, is different. Co-location involves providing continuous power, cooling, and a secure physical space to a business that wishes to house its computer systems at a secondary location physically away from its primary location to protect against potential outages due to weather, fire, flood, power failure, or other catastrophic events. The business purchasing the colocation service retains responsibility for its own computer equipment and the data stored on it. The colocation provider explicitly does not have access to the stored data. So you can think of colocation as more like a shared computer closet in an office building, or even like a self-parked garage than a cloud services company. Our concerns arise that SB 6 defines data processing as including storage, but doesn't distinguish between service providers that have access to the data, like cloud services providers, versus companies that don't, like colocation providers. So we suggest clarifying that distinction so that it doesn't cause confusion or put local colocation data centers at risk, potentially forcing these smaller companies to attempt to renegotiate their customer contracts to comply. We're concerned that that would increase the ability of these large out-of-state providers of cloud services to come into Connecticut, force Connecticut businesses to move their services out of Connecticut, and all of that without enhancing privacy or security for consumers and putting consumers' data at increased risk. At a minimum, we think it would be prudent to clarify that SB 6 does not require a colocation provider to take on responsibilities that would include accessing data. The wording of SB 6 doesn't make that crystal clear, and in fact implies that a data controller could dictate that a colocation provider act as a processor and gain complete access to individuals' confidential data. I promised I'd be brief. So in closing, CHA and its member hospitals have been HIPAA compliant since HIPAA became effective, and we appreciate how important consumer privacy is. We also support extending basic privacy and security rules like those in HIPAA to previously unregulated areas. Of course, when any new legal framework is introduced in technology, there are bound to be unintended consequences due to the complex and ever-changing nature of tech. So we appreciate your consideration of this specific issue related to colocation so that we can work together on a solution that maintains the goals of SB 6 without jeopardizing Connecticut businesses or limiting local options. So thank you for the consideration of our position.
Thanks, John. Are there any questions? I guess I have a question in that one, there is a difference between Connecticut data privacy laws and other states, and that other states have the ability to put out regulations, promulgate regulations. Connecticut, we can't do that for whatever reason. The AG doesn't have rulemaking authority like in the other states. So with that being said, in California, which their privacy law has been in effect, in the language around this in the bills is similar, right? I don't know, are there regulations that clarify? Because California's law has been in effect and they haven't had this issue come up. And so that's what I guess I'm trying to wonder. Did they clarify it in the regs, which is why there's not an issue? Or that's what I need to understand, because looking from the bills and the fact that California's law has been in place and they haven't had an issue with data location in California, I'm wondering why we would anticipate an issue in Connecticut, which is a question I have had, and I don't know why, I just haven't seen that yet. So that's, well, and I do understand, as I said, that their privacy agency puts out regulations that are clarifying. So maybe there's a regulation I need to look at that I haven't seen yet.
Senator, if I might assist John with this, as he noted earlier, I don't know whether it hasn't come up or it hasn't been as important as the other issues. It's definitely a low level issue. We appreciate that. Certainly listening to the professor earlier, who was outstanding. There's a lot of big ticket thoughts that go on and having to figure out the nooks and crannies of how these things work. So the concern that CHA is raising could probably be solved without a statutory change, although that would be best. It could be solved by FAQs or clarity from the Office of Attorney General, which would not be prohibited by the regulatory hurdle that we have that the other states don't have. So I appreciate what you're saying. I don't know that because it hasn't become the focus that it isn't an issue. I think it just isn't a primary issue, except for folks that do this.
Thank you. And I guess I probably didn't state it correctly. I was just wondering if they had found a way to solve the issue that wasn't through legislation that I could be pointed to, or language that would work. But thank you for that that suggestion. And I do see Dina.
Yeah, thank you. Thank you, Senator, and thank you, John and Jennifer. I completely appreciate the issue, but I have two sort of related questions. The first is whether the co-location service providers are treated as business associates under HIPAA, and the second is who's responsible for the physical safeguards at the actual service location.
It's a great question, Dina. So the general thought process now is that there is a discussion like that isn't clear whether you are a business associate or not. CHA takes the position that they are. So they are the business associate of the companies for which they co-locate specifically for physical safeguard, and nothing about that would change. In fact, it raises the issue, right? So if your containment for physical safeguards as a BAA makes sense, even though those folks are exempt from SB 6, you don't want to have that spill over into a technical component. So that's actually the distinction we're trying to draw.
Very good. Thank you so much.
Okay. Are there any other questions? Okay. All right. If not, John and Jennifer, thank you very much.
Thank you, Senator.
Sam?
I still don't see Carl or Senator Rodriguez or Assemblymember Wicks.
Okay. Yeah, we went through a little faster. Would you mind just emailing Carl quickly with the link? I wonder if he had a different.
Yeah, I sent in the link when we started. I resent in the link when we started, but I'll try reaching out to him again right now.
Okay. Thank you. Okay, with that, I guess I don't know if it would make sense just to stand in each for a few minutes, or if anyone had any other questions or discussion.
Senator, would it be possible while we're waiting for you to give us an idea of a timeline and next steps after today, what you and Representative Gilchrist are contemplating? Yeah,
so as far as the timeline, I think Representative Gilchrist, myself, Representative Parker, plan on meeting next week to discuss and kind of decompress all the information we've gathered to decide a scope of the bill. We will be meeting on January 3rd was the plan before, and the session starts January 4th. And so in that meeting, we hope to have an outline of the areas we would like to cover in a bill, but probably not statutory language yet. And I know, so this time it is a little different than last year. We were working off of statutory language the whole time, so it was a little different, whereas this time we're more, last year we were refining, this year we're fact gathering to get ready for the bill. And so I don't know, so we haven't discussed yet, so I don't want to say too much other than we did discuss putting a getting together next week. So
thank you.
Senator Carl should be on now.
Okay, great. Carl?
Yes, thank you for having me.
Okay, thank you. So the floor is yours. So we'll introduce it. Carl Szabo. Am I pronouncing your last name correctly?
Yes, that's correct. You get a gold star for that one, so I appreciate that. Thank you. Good morning, afternoon, everyone. My name is Carl Szabo. I'm Vice President and General Counsel of NetChoice. I'm also a professor at the George Mason Antonin Scalia Law School. So as you can imagine, I'm here today to talk about the California Age Appropriate Design Code Act, so-called, as I would say. And this is something that kind of hits close to me at home because my wife is a child therapist. She works with children. I've got 2 kids. And when I saw this legislation introduced, I thought, oh, yay, this is such a great idea. And then I realized, wait a minute, there's a lot of problems here. And I think we need to begin exploring them. And so let's start at the top with what is age appropriate design? I think the title alone is kind of misleading. I've got 2 kids. One is 9, one is 6. What is appropriate for my 9-year-old may not be appropriate for one of his friends. And so immediately you have the fundamental question of who's going to decide what is age appropriate? Ask any teacher. They've got a classroom full of all kids of the same age, and they're wildly different in emotional, social states. And who's going to make the decision of what is age appropriate? Is it going to be the parents? Is it going to be the government? Or is it going to be somebody in a data center somewhere who codes? And this is kind of the problem that I see is it's asking government and somebody who doesn't even know the kids to decide what is age appropriate. Now, this legislation, when it was introduced in California, was opposed by LGBTQ type groups like Evan Greer at Fight for the Future. And he raised the problem of it is, and keep in mind, Fight for the Future is not necessarily the group that NetChoice always agrees with. In fact, we're often on the opposite sides of many issues, but here we agree. And he described this legislation as, or this law as so vaguely and broadly written that it will almost certainly lead to widespread use of invasive age verification technology that subject children and everyone else to more surveillance while claiming to protect their privacy. So I put together a deck, and I'm happy to share it with the committee. I can send it over after this call that I presented at NCSL just the other week. And essentially, what does this legislation do? Well, let's start with the terminology, the use of the word child, which I think is a misnomer here. When we use the term child in the legal world, in the history of the internet, even in our own parlance, child means somebody under the age of 13. In fact, we use a completely different term when we talk about somebody who's a 14, 15, 16-year-old. What do we call them? We call them teenagers. What do we call somebody who's 17? We call them young adults. But this legislation says, no, they are all children. We will treat them all equally. Somebody who's about to go off to college or maybe is in college today is treated the same as a 3-year-old. The way that this law is written, it applies to any business that provides an online service, product, or feature likely to be accessed by a child. And remember, instead of the word child, I'll say 17-year-old. So any online service or product that may be accessed by a 17-year-old. So what does that include? Well, that would include Amazon, it would include Etsy, it would include Pinterest. Okay, maybe that's right or wrong. What else does it include? Walmart.com, Target.com, CVS.com, the local BarnesandNoble.com. Basically, every website is covered by this because let's be honest, 17-year-olds access many websites. If a encyclopedia service is a business, then they are covered by this. So what's the end result? Well, the end result is this applies to basically every website on the internet, and it has strict prohibitions on things that you can do just through the normal course of ordinary business if somebody is under the age of 17 or is under the age of 18, I should say. So that basically means that you have to have perfect identity verification on the internet. That means every time you go to a website, we not only need to put up an age gate to ask, are you under 18? We need to verify that you are who you say you are. And it can't just be through something you logged into previously, because as we know, many different computers are often used by many different people in the household. So the same computer that my wife uses, my son will sometimes access to go add stuff to like an Amazon cart wish list. This is essentially getting back to what Evan Greer at Fight for the Future was talking about. We are going to have an age and identity verification system on the internet every time you access a website, essentially, to begin to operationalize this from a legal perspective. And it essentially begins treating everyone on the internet as, well, a child. And it's going to harm a lot of communities. And I already mentioned a couple, but it's communities concerned about revealing their identity. So we mentioned LGBTQ communities. Think of a 16 or 17-year-old trying to get more information about that. Pregnant women seeking information about abortions, whistleblowers. This is essentially what we're talking about, is the loss of anonymity online. It's very dangerous. Or just think about protesters and the government being able to have requests for access to this information. This is in part because the law is written as, it says might be or could be 17-year-olds. That's where the liability lies. Typically, the way that COPPA, the Children's Online Privacy Protection Act, has been doing it for 20 years is you have to have actual knowledge or directed to children. Those are the two requirements. Here, this law flips it on its head. Okay, so we're kind of getting into the, okay, Carl, I get it. You think this law sucks, but this seems a little extreme, right? Nobody, everything you're saying, that can't possibly be true. Nobody would agree to that. Let's start by recognizing that this California law was basically based on a European law. While we may support or disagree with many things that Europe does or doesn't do, Europe does not have the free speech and First Amendment protections that the United States does. There is currently a group in England, for example, that goes around and monitors content online and will actually engage in arrests. And we, of course, have examples in France and Germany and many other nations in Europe where the First Amendment clearly doesn't exist. So that's part of the problem. But let's use some actual use cases. So the first use case, and this is in the deck that I'll be sending around, involves a search from Bing.com. And it is a search for the nearest child shelter. So imagine a child trying to figure out where's the nearest child shelter, a 17-year-old, 16-year-old, and they do this Bing search. Well, they can't do that because that would require the collection of precise geolocation information. And that can only be done if it is strictly necessary for the business, product, or service. Now, I'm an attorney. I can argue that, yeah, you need to know the precise geolocation information when you do a search like that. But simultaneously, I can make the opposite argument. Well, you're just doing a Bing search for nearest child shelter. You don't have to show a map where the nearest child shelter is. In fact, you could then do a follow-up question of, well, can you provide us your address? So you can quickly see how the strict liability requirements in this law get perverted. Same thing would be true for directions to a halfway house or something like that. Another example is the law makes illegal the use of what are called dark patterns. And we see dark patterns all over the place. What is a dark pattern? It sounds really sinister. It's not really well defined in the law, but it's basically when you go to a website, and I'll use an example, it's in the deck, it's the International Association of Privacy Professionals, clearly very pro-privacy. Well, they have a pop-up notice about cookies on their site. And they have a green box that reads accept, as in accept the cookies. Well, that would be illegal under this law because you are now using quote unquote dark patterns to steer people to give more information that they would not otherwise give. Okay, fine. What about another example? Well, I went to the website imaginedragons.com. Exceptionally likely to be accessed by a 17-year-old, but I also love Imagine Dragons. Well, you go to the website and they have a pop-up to subscribe for their newsletters. Those types of pop-ups cannot exist under this law. And then the final example I have is barnesandnoble.com. This is a website that is absolutely accessed by people under the age of 18. 16-year-olds go there to maybe add textbooks. 14-year-olds maybe go there to get Cliff Notes. My son, the 9-year-old, I let him go there to add books to the cart that he wants for the holidays. Well, this law makes it illegal to collect, share, or retain any personal information that is not necessary to provide the online service. Okay, once again, this is very fuzzy language. So if they were to retain past book purchases, items that my son adds to the cart, items that my son adds to a wish list, even if I consented to it, that would be illegal under this law. That's what we're talking about here. When I was given this presentation in California at the NCSL event, the proponent of it, who I believe spoke to your committee last week, said to that room, this law, which she helped write, is intentionally vague to provide maximum flexibility. So you are looking at a law that is untested, that is unapplied, that will result in the collection of more personal information, that will impact minority communities and communities at risk, that will help to eliminate anonymity on the internet, that is unoperational, and it is clearly a bad law for California. It is clearly in violation of the Constitution, and I go through all the constitutional and legal problems about that as well. But the underlying question is, what is the goal we're trying to achieve? And the goal we're trying to achieve is to what? Help protect all of our kids online. One thing Connecticut has not yet done is created an educational program in schools, create an educational program in libraries and community centers to teach teenagers, to teach parents how to use the tools that we have today. And that, I think, should be the first step, is give teens and parents tools and education they need, rather than head down this road, which will shut off the internet for many people, which will violate the Constitution, and will actually create honeypots of personal information on all of us. And thank you very much for giving me the time. Sorry for being a couple minutes late. My email got lost in the email universe of whatever, but I do welcome any questions you have about the law.
I guess I have questions more about the UK, the age appropriate. And I understand there won't be the same constitutional challenges. So I have two questions. So actually, we'll start talking the constitutional challenges. Are there legal challenges to the California law currently?
I expect there to, yes. So I expect there to be legal action very soon. And these will stem from simple things like the First Amendment problem. So there's a case, this law is basically a copycat of something California tried years ago against video games. So a very famous case in the legal community, it's now actually become a bedrock of First Amendment law, involved the Brown versus Entertainment Merchants Association. This was where the state of California made it illegal for stores to sell video games to teenagers. Dangerous video games to teenagers. That was challenged all the way to the US Supreme Court. It received similar support from groups like Common Sense Media that this bill did, but it received robust opposition from First Amendment groups. And in a 7-2 decision written by Scalia, but joined with by Kagan and Sotomayor, amongst others, they said no, the California law prohibiting the sale of video games to 17-year-olds is a violation of the First Amendment. And what you are seeing here is a copycat of that, except it's now just the internet. So it's even broader and less constitutional. So it's going to have that First Amendment problem. Second is something called void for vagueness. As you know, as lawmakers, you need to make clear what the laws are, especially when it comes to speech, so that people know how to obey those laws. You can't just put up a sign that reads, drive a reasonable speed. You put up a sign that says drive under 35. So the constitutional challenge there is on void for vagueness, of which this law is replete with those problems. There's also a preemption problem in collision with COPPA, the Children's Online Privacy Protection Act, which expressly prohibits states from creating laws like these for those under the age of 13. So those are just three of the constitutional problems that are being faced with this law. So to answer your question, the first question is, do we expect a challenge? Yes, very, very soon. And to answer your second question, as I laid out, I mean, there's already a Supreme Court law that's almost identical to this on the books today.
Thank you. Now, I guess my next question is, what has the UK Age Appropriate Design Act resulted in? Because, you know, Amazon, Barnes and Noble, they sell over there. Do they age gate in the UK? I know that they have some approved age verification methods. You know, again, I'm probably not stating it correctly, using the correct terminology, but yeah, if you could just talk about, are they age gating over there, or what has happened in the UK where this is a fact?
So one of the problems that we've seen from GDPR, which is the General Privacy Directive, I forget what R stands for, that's the European privacy law. That's a good example to start with. That's a law that applies to every single data collector on the continent. There's been exceptionally little enforcement of it. And with respect to the law in the UK, similarly, we've not seen very much enforcement, and there are likely many businesses that are not in compliance with law. So you have, at the end of the day, a law that is not being either enforced or applied. So neither of which are good. Here in the US, we have a similar but different problem, which involves the way that we do law enforcement here we do enforcement like this here in the US. So let's take California, for example. The way it's written, it's still an open question as to whether there is a private right of action in the law. It says expressly there isn't, but then that collides with another provision of the statute that says a greater statute in which it rests that says there is. Let's assume for the sake of argument that there is no private right of action. One of the challenges that you then see is how AGs end up enforcing this. And what oftentimes happens is you'll see the equivalent of privateering that you don't really see in Europe, where basically a trial bar, a group of plaintiffs' attorneys will approach the AG with a suit and say, if you let us take this suit and run with it, we will kick back money to the state, and we will, of course, take part of the profits. You don't see similar problems like that. So what ends up happening here in the US, because remember, Europe does not operate on the loser pays, or Europe and the rest of the world operates on a loser pays model. The US doesn't for litigation. So what ends up happening is you get in-house counsels like me, or like my prior job, coming out and saying, okay, we can't do A, B, C, D, and E. We need to protect ourselves. And you end up with a situation like what we have seen in COPPA, where you do get this absolute desert of content for those under the age of 13. So that's the challenge, is you can't really compare us to Europe because of the way that they enforce their laws, the way their litigation system works, and the fact that they do not have protections of free speech like we do here in the US.
I see Marion has her hand raised. Marion, would you like to ask your question?
Sure. Thank you so much, Senator. So I appreciate the perspective. I'm just curious about what else you would suggest besides the education piece, because as we know, schools are already, grossly underfunded, relying on schools or other educational programs to provide those resources and information for teens and their families will disproportionately negatively affect communities that are in lower socioeconomic areas of Connecticut. So I'm just curious, what else do you suggest? Are you saying that there is no legislation that could be passed or no provision that we could consider that would address the issues that we all agree are of concern?
One of the challenges, and I struggled with your exact question quite a lot in my own life. It's tough to be a parent. Like, frankly, this is the challenge for my generation, for my wife, for many of the people on this call, for many of your citizens. And the thing is, if I have the arrogance, if I have the assumption, because my wife is a child therapist, she sees this firsthand. She deals with everybody from 12 to 18. If I have the arrogance to think my kid will not be better at tech than I am, then I'm deluding myself. And the last thing I want to do is give parents a false sense of confidence and ask them to not do their jobs. There are incredible controls on these devices that most of us don't know about. And a simple example is, this is not the first time we tried this. We had the V chip. And you're all probably looking at me like, what the hell is the V chip? It was in every single TV sold in the late 90s. And it was a device to control content on televisions. You don't know about it, even though it was there. It was mandated by law to be there because nobody knew about it. The education campaign wasn't there. So what I'm saying is, and I appreciate the underfunding of schools, and I'm suggesting this is something you want to fund. This will provide incredible value long-term, because I, as a parent, can hand my kid a device. If I, as a parent, don't understand the capability of that device, how to secure that device, that's not only dangerous from a social, emotional level, but from a cybersecurity data theft level. So you got to educate parents. You got to educate kids on how to be good digital citizens. I think this is critical as well. And this legislation doesn't address any of these problems. It doesn't address any of these problems because kids are smart. Teenagers are incredibly smart when it comes to tech, and they know how to do end runs around many of the things that we're trying to achieve here. So that's my thing. I mean, if we haven't tried educational campaigns in schools, and I'm not saying educational campaigns per se, I'm saying build it into the curriculum. You teach reading, writing, and arithmetic. I think learning how to operate online is an important component of that education. Let's try that first. Let's see how that goes before we immediately assume that's not going to work.
Chair, I see Chair Lamont has his hand raised.
Thank you very much, Senator. One quick point and then one question for Carl. First, on the comparison between the California Age-Appropriate Design Code and the United Kingdom's ICO code, I think there are some definitely close relations between those two laws. They're very closely related. One is somewhat built on the other. However, there are some key differences. My organization and my colleagues at the Future Privacy Forum recently released 20-page kind of comparative analysis between some of the key provisions in each of those codes and how they're situated in the broader legal context. Would be happy to share that out with the committee afterwards if that's something that would be potentially of interest.
Yes, please.
And then secondly, question for Carl. I was wondering if you could drill down kind of a little bit more about your points on age verification, age gating, and how you're kind of reading the requirements under the California Age-Appropriate Design Code. We had some speakers in the last meeting who were kind of addressing this point from a bit more of a positive angle, saying, look, age verification is not required under the AADC. It's estimation based very directly on the risks the product or service presents. There was also some discussion about companies potentially already making some of these estimates or kind of having information that would allow them to do this already. Could you describe a little more in a little more detail how kind of you see potential issues about what the AADC may or may not require businesses and companies to do?
Yeah, at the end of the day, AADC is a strict liability statute. So I will just give you one example, and this was from my Barnes & Noble slide. You are prohibited as a business if, and remember, I will say business writ large, because it's essentially any website that might have a 17-year-old visit it. That's the scope of what we are talking about here. And it reads, you may not collect, sell, share, or retain any personal information that is not necessary to provide an online service unless the business can demonstrate a compelling reason that retaining is in the best interest of the children. Okay, and remember, children is 17-year-old in this case, I'll say. I could show you a reason why I think Barnes & Noble collecting the books that the history of the books that I looked at is a compelling interest of the child. I can say, you know what? it's compelling interest because it helps me direct them towards a better book or a next one in the series, or helps them with their next purchase. Let me give you a counterpoint. Not, you don't have to be a genius attorney to come up with the alternatives. Like, well, you are collecting that information and collecting a dossier of all the books that a 16-year-old has looked at and considered purchasing. Could be accessed by malefactors. It could be accessed by somebody who goes to the computer and is able to see the history of every book that they've looked at. How is that possibly in the best interest of a child? And that's a challenge. That's a court level decision. Best interest of the child is an exceptionally legally charged term. We use it in determining custody battles. And that is heavily litigated, hundreds of lawyer hours, and it still doesn't have legal certainty. It's one of those, I know it when I see it statutes, requirements. And the problem is with the penalties that are associated with this. Remember, the California law has 2,500 up to 7,500, 2,500 to 7,500 in statutory damages. So I wrote down the math, and let's presume you have a group of 100,000 17-year-olds. Well, now you're looking at damages of 2,500, 100,000, 2.5 million, I think, if my math's correct. And that's just for the 17-year-olds who might have accessed. So immediately, if you're looking at in-house counsel with this loosey-goosey, intentionally vague statute, you are going to lean towards legal certainty. And so what becomes a, well, you're guilty until you're proven innocent standard will turn businesses into completely locking down their sites because of the penalties associated with this, the flexibility in enforcement, and the uncertainty that this law creates. That's the problem. There is no rebuttable presumption here. Essentially, you are guilty until proven innocent, because the definition I gave you is you are guilty if you collect unless you can demonstrate. And that's the challenge. And that's how businesses are going to respond in a way that will be most protective of their business. And that's how you end up with the data action required. Now, turning to the point about age gating. So if they told you you can just do age gates and that will be fine, that's inaccurate. That is straight up inaccurate, because this law does not say you have actual knowledge or you did an age gate or something like that. This is, did you collect information from a 17-year-old? So much like we do with many other statutory laws and strict liability laws, if you're in a bar and you serve somebody underage, it didn't matter if they presented you with a fake ID. That's what this is doing. So how does a bar get around that? Well, they collect your ID, they check it, they verify it, they look at you, they look at the ID. That's what we're asking every single website on the internet to do before you can even do a Google search. That's how this gets applied. So a simple, are you 21 or not, or are you 18 or not, will not get you out of jail. And that's why you have law school professors like Eric Goldman out of San Diego State University, or sorry, Santa Clara, explaining this in great detail, how this will annihilate anonymity online.
Appreciate the response.
Thank you, Kim. And Carl, thank you very much for your presentation. If you could send along the slide deck, I would appreciate that. We will get that information out to all of the members. And if you have any other points you think, well, we'll review the slide deck and then probably reach out with additional questions. But thank you.
No, thank you very much. And make sure you have your snow shovels ready.
Yeah, unfortunately.
And good luck.
Oh, okay, where I am on the coast, but up in the northern part of Connecticut, I think they're going to get some snow over the weekend. So thank you. Okay, Sam, next.
Next should be Assembly Member Wicks should be on now.
Great.
And Senator Rodriguez should be on soon as well. I just got an email.
Okay, great. Thank you very much.
Mhm.
So now we have with us Assembly Member Wicks, I apologize, who is one of the prime drivers of the California Age Appropriate Design Code, to talk with us about the California Age Appropriate Design Code, which we last week were fortunate enough to have our Five Rights Foundation also speak to us about this. So Assembly Member Wicks, the floor is yours, and thank you so much for making the time to speak to us.
Thanks for having me. It was really interesting for me to hear the previous speaker's rendition of my bill. I have to say I don't agree with much of what was said, but I'm happy to chat through and answer questions and just give you my take as the author of the bill. I did this bill with one of my colleagues, Republican Assembly Member Jordan Cunningham. It was a bipartisan bill. It had the most support in the Assembly and the Senate, probably more than any other bill in the legislature this year. Got off the floor of the Assembly 76-0 of 80 members, so had real strong support across the board. You know, Jordan and I kind of came to this because we're parents, you know, and we were struggling with how do we provide safer places for our kids. And how do we do so in a way that is impactful, meaningful, isn't punitive to businesses? We want them to exist. Turns out the internet is not broken in the UK. People still use the internet. 17-year-olds still use the internet, et cetera. And so we looked at what had been working in another place and decided to do it here in California. California, obviously home of the tech industry in many ways. And it's a big economic driver for us here in California. I'm in the Bay Area, so it's a big economic driver for my own district. So I wanted to be really thoughtful about that as well. Obviously, I don't want to do anything that would, you know, negatively mitigate our own economy. But I think we can both have a strong tech economy and keep our kids safe. And that's the balance we were really trying to strike here with this bill. We worked really closely with Five Rights on the bill. And I think you had them, I believe you had them last week. Is that right? Or recently? Okay. So
we had them last week.
Okay, great. So I think they may have given you kind of a sense of what the bill is, and sounds like you've gotten some alternative views here, which I think is important, obviously, to hear. But you know, we've seen success in the UK with the bill that was passed there, and so we wanted to really model, you know, something similar here in California. We've done a lot of work here. You know, 4 years ago, we enacted the California Consumer Privacy Act, or CCPA, and I know other state laws in other states are similar in nature. We also passed by ballot measure 2 years ago, creating a new privacy agency, regulatory agency here in California. So these historic bills, you know, catalyzed the tech industry to significantly increase consumer privacy here in California and beyond. But we know that the work's not done, right? And so these laws help ensure transparency and give consumers more control over how their data is used. But prior to the passage of the Age Appropriate Design in California, there was no comprehensive law that protected all children under the age of 18 from potential harms, you know, stemming from online products and services that they are likely to access. And this isn't about like regulating the PBS Daniel Tiger app, right? You know, that's a pretty safe place for kids to be in. It's more sites that they are potentially going to be accessing, because we know that they're accessing all kinds of stuff. But, you know, in short, it requires businesses offering any online products to identify any risk of harm to children likely to access their product and mitigate or eliminate that risk before the product is available. So we're really trying to do, you know, upstream, as opposed to, you know, being punitive after the fact once harm is done, but to really go upstream. And we see this requirement. This is a requirement with sort of automobiles and seat belts and child-proof pill bottles and kitchen appliances and all kinds of other things. So this is essentially that applied to the internet. And we think it's reasonable, workable, and we think it's also necessary. We know it's workable because we've seen it in the UK for over a year. And contrary to early big tech opposition arguments, again, the internet didn't break there and people still use the internet there. In fact, the result has been really the opposite. Many online products, services, and features that youth are likely to access have created a much safer, you know, more welcoming place for children and teens. the whole premise of it really is to create sort of high privacy settings by default. And, you know, things like, you know, disabling the profiling of children by default, you know, limiting the collection of precise geolocation information unless it's necessary, you know, et cetera. And I think some of the, you know, things that we've seen sort of fundamentally in the UK that have changed, you know, Instagram now prevents adults from messaging children they don't know, you know, and prior to that, DMs were open. If you were a 13-year-old with an Instagram account, 40-year-olds can be direct messaging you, you know, that were not part of your network. It turned off, you know, location tracking, and introduced prompts that encourage children to take breaks from scrolling, because we've seen a lot of like that addictive behavior online. It made Safe Search the default browsing mode for children under the age of 18. It turned off YouTube's autoplay function. And I have a 6-year-old. Autoplay is like a very difficult thing for us to navigate, but making it by default turned off is what we've done, but now that will be like the default. You know, TikTok recently made accounts for those under 16 years of age private by default. It also turns off push notifications after a certain time period. So there's all these very tangible, real things that are now happening in the UK that are making the product safer for kids online. And again, people are still using the internet. Kids are still accessing stuff. You know, I'm not a Luddite. You know, again, I represent the Bay Area. I have kids. They're digital natives. I just want them to be safe. And we very much view this as a very reasonable bill, much to the contrary of some of the stuff that you may have heard. And we've had a lot of support amongst the tech industry, a lot of support amongst academics, a lot of support, bipartisan support on the bill, because we do think it can be really useful and helpful in a way that isn't too punitive to companies. And I will say the other important thing is there's right to cure language in the bill. Basically, the idea was we're not trying to screw companies here. We want them to do the right thing. We want them to be intentional about the products that they are creating and how those are impacting kids. And generally, I actually believe, you know, I did a lot of meetings with Meta and Amazon. I mean, you name it, we met with a lot of different companies. I think a lot of them want to do the right thing. You know, they're parents too, right? They're seeing the impacts of technology on their kids, right? It's the question of, is this, you know, keeping kids' privacy safe and keeping them safe online? Is it priority number 1, 2, or 3 in their Monday morning C-suite meetings at 9 a.m. or is it priority number 40? And so what we forced to happen now is that it's a top priority, right? It has to be, because it's now a regulatory issue. And again, I met with a lot of different people in the tech industry, and I genuinely think they do want to do the right thing. We just have to force their hand a little bit, you know, and we worked closely with them. And while they didn't love everything, you know, we got to a place where I think a lot of them also understand that regulation is necessary. And so can we do it in a thoughtful way that doesn't, you know, have any unintended consequences? And I think that's where we've landed with this bill. So that's my sort of quick take on it. And I'm happy to answer any questions that folks may have.
I'll open it up to questions. I just want to say thank you. Really, thank you very much for taking the time. I probably will reach out to you separately from this just to find out, you know, if you have advice on who to work with as we go through crafting this. Senator Rodriguez is presenting next from Colorado, and he was very helpful when we were working on the Connecticut Data Privacy Act and telling us who he had worked with, who gave him good advice. I think we all start from a place that we want to keep our children safe, right? My son's 16, so he's still a kid.
You're in the thick of it, right? With teenagers, yeah.
And so it's just, how do we get there? And I also understand it is difficult between keeping things, you know, technology changes faster than our ability to regulate it. And so how do we make laws that are flexible enough to change with technology, but then also they provide guidance to businesses so they can comply? It's a difficult sweet spot to find.
And just on that point, actually, I mean, I agree completely. I did a bill the year before that was much more the legislature really weighing on specific components of technology. The challenge with that, right, is 6 months later, everything changes. A year later, everything changes, right? And so this bill really empowers our regulatory agency to put forth the right kind of framework, creating, a working group kind of task force comprised of industry people that are experts in the industry, academics and others, to really think through the types of regulations we need, because it changes so quickly. And it's not easy stuff. It can be complicated, for lawmakers. And so really empowering our regulatory agency, we felt like was the best way to kind of thread that needle.
And unfortunately for us, fortunately, we have a great data privacy unit within our Attorney General's office, but unfortunately they don't have rulemaking authority. We don't have a separate privacy agency. So we have to put in legislation a lot of these things, and we don't have the ability for the agency to, but our regs process takes a long time, unfortunately, here too.
Sorry, one other thing I'll add, there isn't a private right to action in the bill. It's the enforcement mechanism is the Attorney General, and who I have a really good relationship with. I've talked to him about this bill quite a bit. The enforcement question is always a tough one in lawmaking. How do you actually ensure that your bill, like when it becomes a law, that it's actually enforced? We felt like the AG was the best place for this to land, but I'm going to be monitoring that and seeing, if that is the right thing, and maybe we'll need to do amendments down the road on it. But we felt like for now that was the best place for the enforcement mechanism.
There were a lot of similarities in your presentation, and actually we're also looking at regulating AI, algorithmic decision making, and we had a Professor Suresh from Brown on earlier talking about the White House's framework. And one of the things was he actually used the car example as you did, where it's on the companies to certify, and sometimes it's different depending on the risk, how you would regulate, right? And so, but I am interested in looking at those, with the algorithms, but also with children, looking at this impact assessment ahead of time, right? And trying to correct it. And do you guys do anything in terms of, I know there's likely to be a concern from companies. What if we find something that's harmful, but we fix it? Are we opening ourselves up to liability by disclosing that we found this?
Yeah, that's why the right to cure language from my perspective was actually, that's what the tech industry wanted. And I actually felt like it was very reasonable, because again, the goal is not to destroy the tech industry. The goal is not to destroy these companies. The goal is to actually make our products safer. And so if we're finding that there's a problem, we meaning the companies, and they're making the product safer, that's the goal. That's what we want to have happen, so there shouldn't be any punitive measures with an example like that.
And I guess I'll see, does anyone else have a question? I don't want to monopolize the questions. I haven't seen any hands raised. So, well, thank you very much. As I said, if you don't mind, I'll probably reach out to you by email separately from this to ask some additional questions.
Happy to. Thanks, everyone.
Thank you so much. Okay, Sam, I see Senator Rodriguez. So, we have Senator.
Good morning or good afternoon, Senator. It's good to see you.
Yeah, good afternoon. We're 12:30 p.m. here. Thank you so much for taking the time to present to us.
Yeah, sure. Good afternoon, everybody. I'm Senator Robert Rodriguez. I'm the senator from Colorado who worked on the Colorado Privacy Act. Senator Maroney has invited me here to just talk to you guys about Colorado is the only state so far that's included nonprofits in their privacy policy. And just wanted to explain the process of why and what came of it, and why I feel it's important, and to answer any questions if you guys disagree or discussions. Currently, we're in the process of rulemaking. So that's been going pretty well, and the feedback's been pretty good, and haven't seen much that we need to change in our bill, maybe some press stuff, but haven't seen if we need to do it or rulemaking will allow it. But as a discussion for nonprofits, the simple answer for me is, I don't understand, with the amount of data and everything being electronic anymore, I don't understand what somebody's tax status alleviates their responsibility for what they do with the amount of data that some of these companies collect. Should they have responsibilities for the data that they collect and implore? I think there's new technologies coming out that's going to assist them as our policies pass in other states and this stuff starts getting developed. But at the end of the day, you see a lot of nonprofits that don't know the information they're collecting and sharing. I have an article that I did for a tech paper about why we covered nonprofits and some of the information. But one of the interesting things they had was a tool that you could put their website in it and would show you all the tracking that the websites had. And as I got pushback from some of the nonprofits and the papers and stuff about it, they had no idea that their web browser was tracking information that was probably going to the person hosting the website. And I think it was eye-opening for them, but I do think you have nonprofits that some of these for-profit companies either form to do some research and stuff that pay in that are on the boards that have this. And I think some of them being excluded, maybe using the nonprofits to hide this data, but some of them are, large amounts of data and they have no accountability for whether there's leaks or whether they're doing protective. And just the fact that we have strong impact assessments in our bill gives them the opportunity to see what data they're collecting, because as many of us know with data collection, most companies aren't doing the minimalization and only collecting the information that they need to process the request that they're looking to process. They gather everything to find out if at some point they can either utilize it for something better for them or monetize it, or somebody will buy and sell it or trade it or whatever is being done with the information. And why these industries would think that they have no accountability to consumers' rights and whether they should be able to see what they're collecting on them, what other stuff. As you know, you can track people's keystrokes, you can track where they go before. I don't know if nonprofits are utilizing this or not, but why should they be excluded from any responsibility anybody else has that's collecting large amounts of data? So in a brief nutshell, and I'll forward some of that articles, but there was an article, the person that's doing it in California who did an audit on the ACLU, they didn't know that, their department puts all their email lists to targeting into Facebook, huge data privacy breach of information being shared out. That what's Facebook do with that information once they have those lists? So I think there's a lot of unintended knowledge from the nonprofits about the information that they collect and are using and utilizing and what's being done with it, because they've never been held accountable to the information they have. And as any of you have newer technologies with your phone, I'm always getting information of my password being leaked or out on the dark web. And how do we know where they got that information? We have no idea where they get it. So I don't understand why any industry, and for me, I wish I would have got government covered in my bill as well, but I don't see any reason why any industry that plays in this space with data collection and information, that they have no accountability to what they're collecting and protecting it. So happy to answer any questions or anything, Senator Maroney, you have, or.
We'll open it up for questions. I do have, I'll start with, could you share that tool with us that you can put in and see what data is being tracked?
I will. I have to find it. I got Cora and I put in a big folder when I had to send it all out, and I have to go and find that folder and do it for it. I couldn't the day. I think my aides put in a different somewhere else when they move stuff around. So I will find that article and send it to you. It was a pretty interesting tool, and I'm sure a lot of other sites do it, but in the technology now where everybody's working from home or providing, and people are using their own personal computers and they put people's software on there, and you don't know what information is being collected at the workplace with that information too. But I will find that. So I will find it and send it to you so you can share it with the group.
It will share it in your article as well, if we could share that with us. And Professor Sadir has his hand raised.
Yes, I have a question for you. I really agree with you that, the need to cover large nonprofits as part of the data privacy laws and all of that. I was just curious as to, I think one of the objections, or one of the reasons why they have given exceptions is there are lots of small people probably trying to do small things, and and could they get caught in the web? And I also generally agree with you that, like, once these kinds of requirements are there will be cost-effective data, technologies that will come to help solve these problems. So it's a little bit of a transitionary period so that we don't kind of, kill initiatives from the nonprofit sector in the short run. And I was just wondering how that was thought through in terms of the trade-offs.
Well, I think we're discovering and discussing through the trade-offs that are coming with that. I mean, the market is what the market is. While this may be more requirements and some cumbersome trade-offs that are going to come, I think where there's a will, there's a way. So when an opportunity happens, that somebody can find a way to remarket or re-advertise or re-solicit their donors or however they do it, I think that stuff will start getting cleared out. I mean, it's always been about, you just have to let me know what you're doing with what I do. If I sign up for your thing and I give you my email and you put something saying we could use this for marketing or reaching out or share with others, then I go in knowing that. I think most people have no idea when they sign up for something of the information that it's collecting. And I think the technology will advance. I mean, over the 2 years we passed this bill, I think just the amount of changes that have happened, whether it's cookies or the new technologies coming, whether it's cybersecurity is getting more involved with privacy now than they were before in the past. And biometrics and facial was always thought of a law enforcement tool, and that's becoming more of a popular thing being used in the public spaces now. Whether it's, we have a concert venue here that's starting to look at ticket venues with scanning your palm. What are you giving up when you give that technology away? I have GPS, I have all this stuff on my phone and the facial stuff. I know what I'm doing when I share it, but I think we have to start rethinking. And, as more things are going more data intense, what information do we have and what rights do we have to protect what we're doing outside of the process that we're utilizing? I hope that answers your question. I think the nonprofit sector is up in arms right now, at least in Colorado, because they don't know what to do. My process with them, when I met with them, with some of them, it didn't come up as much as maybe other states did, but most of it was like, just exclude us because no other state's done it. And I'm like, that's not a solution. That wasn't a common sense issue. I'm hoping with the rulemaking that's going on with the AG's office, that's going to get threaded out, that if something needs to be tweaked, absolutely, we're happy to do it. I think the switch gives some interesting issues with the nonprofits that solicit and stuff like that, and how it works and interacts. But I also believe the technology could be customized to fix that. So.
Great. And Professor Sudhir, would you mind sharing your article with us on the article in terms of your research on when people feel more comfortable with data, they're more likely to share that?
Sure, I'm happy to. Yes.
I'll send that out to the group as well. I think that's it.
It's so interesting, as many of you are probably seeing all the pop-ups for your cookie allotments, then you read through them on your web things on your phone and stuff. And I got in the habit of actually going and checking them and selecting them and deselecting them, and finally realized I don't even know why I'm doing this, because I know they're not applying it to my state right now, so it doesn't even matter. But
now, I apologize. It's been a little bit since I've read through the Colorado bill. Do you have a revenue requirement?
I believe we have 100,000 records or higher, or up to 25,000 if there is a revenue, if there's revenue generated.
Okay. All right. So you don't have like some states or some, I forget, it was the business had to make a certain revenue, but you're just on a number of residents whose data is collected.
Yeah, 100,000 records is a lot of records.
Right. So you really,
if I could get my email list that big, I'd be very excited.
So that was kind of my question. Sorry, that was kind of my question. Are there some exceptions even for the nonprofits? So if they do have 100,000 records, that should protect a whole bunch of small guys.
Yeah, and at some point, maybe we need to bring that down as the technology changes and the stuff comes, but you can't stifle innovation in small startups with some of the cumbersome things that aren't able to do. I mean, some of these nonprofits that we're having problems, I go look up their 990 and they're making 20, 30, 40 million dollars a year in donations. And I'm like, I don't understand why you have no accountability to protect your information and you know, and the other opportunities that the bills create.
And yeah, that's a good point. I looked up one nonprofit in Connecticut. It's $750 million in annual revenue, and so
May not have the protections they need for the data or leaks or information they're collecting.
right. So I guess, what was the pushback you had received from the, you know, obviously small nonprofits, but for the main part they would be exempt because there aren't a lot of small nonprofits that have the data on more than 100,000 Colorado residents.
You know, interestingly enough, probably the ones that gave me the most pushback was the colleges
and higher ed in your
higher ed, and the people that collect data, that like College Board and some of the people that do data information on students and stuff. They were probably the ones that were like, you just need to exclude us. And then, like I said, I'd go look up their income and I was like, you guys collect a lot of information. And right now, and we haven't done it, maybe one year I'll get some time to do it. But if you followed any of the privacy circles, children's privacy is a very particularly hot topic right now. I think Connecticut's bill is probably a little stronger than mine. It was something that we tried to get into, but the thought process wasn't, we didn't put enough time to do it well and right. So, you know, we put in some protections to give some rulemaking around it. But I think Senator Maroney probably touched it a little bit more, getting into the nuances of the age from 16, 13, or 18, and some of the informations that could be lost with privacy or things that could happen to kids. Yeah, that's a lot bigger conversation.
Yeah. Are there any other questions? I do have one more, I guess. Are you looking at any, you know, in the post-obs world, are you guys looking at doing anything further with healthcare data next year?
We excluded HIPAA stuff that was covered, but what we didn't exclude was entities related, because, you know, some of these companies, well, you know, the HIPAA, everybody always cries HIPAA, but nobody realizes that it doesn't apply to everybody who screams HIPAA. You know, it's, if you're a provider, and interesting things I've heard from companies, some of these nonprofits are sharing health information amongst each other. So if somebody gets injured in another state, that they can provide that information through a network, which I think should be covered. You know, do I know if my information is being shared, or, you know, there's probably some security on it. But again, I can see the good in it, but I also am concerned with if something's happening with that information. I have no plans to attack HIPAA. I think I'm looking at a biometrics bill this year. I'm happy to get with you guys. I really want to dig into AI. I think that's a new emerging trend that we need to get ahead of. And biometrics is changing so fast with Meta and eye scanning, and the ability, you know, where that's going to go now is super freaky. I don't think people are even contemplating the amount of information of things you look at and what they're looking at your eyes and the amount of information they can collect. It's kind of scary. And I don't want to be where we are on data privacy, where it's too late. You know, I would have preferred opt-in. I don't think the United States is ready to opt in and check every checkbox as they click through a website, like they probably have to do in the GDPR. I could see that not being popular here. And, you know, while it's probably better for people, I just don't think it's realistic for us to do. And I also think EU is having issues with the stuff they've done too. So, you know, there has to be some reality with this. There's always a balance for convenience and protecting rights.
Thank you. Thank you so much.
No,
are there any other questions? Okay. Hearing on Senator Rodriguez, thank you so much. And I will most likely be reaching out to bother you and ask questions on.
I'll find some of my articles and information and send them to you to pass on, and look forward to getting with you and working on stuff. I think some of the work you're doing is genius. And I think with privacy and in this information, the technology world, I think trying to get multiple states with some uniformity is genius and great policy. So excited to work with you in the future and see if we can align on some policy stuff. So
yeah, no, I think the more we can work together, the better it is for all of us. So thanks.
As somebody who, like me, who's been through this bill in the tech companies. I think everybody is I think some uniformity is always what's needed with this policy.
Yeah. Great. Thank you very much. Happy holidays.
All right. Happy holidays, guys. Thanks.
With that, I think we did go over a little bit before kind of the next steps. We have a meeting January 3rd. We will be sending out information to you ahead of time before that January 3rd, and then we'll circulate the slide decks from today, a few of the articles that were referenced, and then Representative Gilchrist, Representative Parker, and I will be getting together, and then we may have some information that we'll send out to you in terms of where we're thinking of going. But with that, Representative Gilchrist, I don't know if you have any other comments. I also forgot to congratulate you on your appointment as the co-chair of the Human Services Committee. So.
Thank you very much. No, this was very informative, and I look forward to our next steps.
Thank you so much. And Representative Parker, was he able to join us? I know he had a busy morning. He was going to try to join.
Hey, Senator. Just saying thank you. Thanks to all the presenters today, and looking forward to meeting with you folks again next week.
Great. All right. Thank you, everyone. Thanks for your time. And if you have any questions before our next meeting, feel free to reach out. Happy holidays to everyone, and we look forward to seeing you on January 3rd.
Thank you, Senator. Happy